listening to Planet Green Trees, episode 189. I'm calling it Section 8 in PTSD. I'm your host, Michael Komorn. Welcome. And of course, this is Michigan's premier medical cannabis and cannabis reform blog talk radio show, and we are here to bring you nothing but the very best and up-to-date, informative, and current events happening in Michigan and nationally and internationally. And to help me bring all the Birmingham Compassion Club.
Good evening. It's nice to be here.
The one and only and much contributor to the show and all throughout the community, the one and only Compassion Chronicles editor-in-chief, Rick Thompson.
Hello, everyone.
Rick, of course, will bring us the news a little later. And missing from the studio, but I understand on his way. He's at a event promoting medical cannabis at some location somewhere, as he does probably every night of the week. The producer, Jamie Lowell from Third Coast Compassion Center. We're looking forward to him showing up soon. All right, so PTSD today, of course, is March 6, 2014. Calling number is 1-347-326-9626. The Michigan Medical Marijuana Review Panel met this morning in Lansing and voted to recommend PTSD as a qualifying condition for medical marijuana in Michigan. The affirmative defense, which we're going to talk about already, a challenging scenario for many defendants and the lawyers throughout the state, has been made even more difficult by recent rulings in the Michigan Court of Appeals. Also, the Institute for Public Policy and Social Research held its 19th annual fundraiser tonight in Livonia, which includes several members of the Michigan House and Senate. Joining us, attorney Joshua Covert from the Nichols Law Firm in Lansing to discuss Section 8 defenses under trying circumstances, as well as other legal issues concerning medical marijuana. I think this is an important part of the show because it should be someone other than myself who's complaining about some of the challenges that are taking place in court. We're going to get into that. Steve Green, advocate and patient, gave extended testimony today at the Marijuana Review Panel. I'm sure he had his cult following with him, as he's been accused of. No, I'm just kidding, of course. And we'll give an update on the proceedings and recommendations to include PTSD as a qualifying condition. Added late to the list, but definitely very significant to the show's our friend Dave Brogren. He's on the actual new conditions panel. He's going to give us his thoughts and commentary on what transpired today and maybe what people can do to help out, if at all, for making sure this thing goes through. Political leadership program that is involved with the fundraiser in Livonia, featuring former Governor Tim Pawlenty of Minnesota and former Governor Bill Richardson of New Mexico. I'm, of course, going to rant a little bit, and we're going to have Rick with the news and people calling in and all kinds of exciting and entertaining things happening tonight. Before we get into this a little deeper, I want to give a big shout-out to some people that are very important to the law offices of Michael Komorn and the show, my friends Pam and Dewey. Looking forward to seeing you guys soon. And thanks, Dewey, for all your hard work and getting me around when I need to be. The Michigan Medical Marijuana Association, michiganmedicalmarijuana.org. I want to thank all the moderators and administrators that volunteer their time, making that forum a safe and comfortable place to evolve the conversation about medical cannabis and cannabis reform. Komorn Law, 1-800-656-3557. Our friend over at the Marijuana Ranch, call for a tour of the Cultural Center, 1-313-422-5281. Some danger in Detroit, though, I understand recently. We may want to lay low. Lay low. Dr. Kumar Singh of the Green Light Clinic, 248-390-0574. As we'll hear tonight in different contexts, I'm sure, the discussions of Section 8 always return to the doctor, and I can tell you that you were likely to have a much greater chance of success in your proving of your medical marijuana defense if you've got a doctor that's willing to come to court and testify. You've heard me talk about Dr. Kumar Singh as a qualified physician that takes the certification process very seriously and, in fact, was certified as an expert in the medical marijuana program in a trial that I had recently in Oakland County. Also on that list, not to keep anybody out, I would say we've got our Dr. Paul Meyer out of Saginaw, Dr. Robert Townsend, Dr. Crocker, who was also on the New Conditions panel, and make yourselves available with a condition that you want to come to court and testify, and you're going to maintain a solid quality patient chart for the patient. Anyways, I do want to shout out to my good friend Eric Gunnels, trustee for Thetford Township in Genesee County, and he was going to try to make it down to the show and give us his thoughts and commentary, but I understand he's not be listening at home. Eric, call in, tell us what you're thinking about tonight. And so let me rant a little bit, and then we're going to take a break. And, of course, of this every week, there's so much to talk about, so many issues that are happening, and I'm excited, I have to say, about the progress of the PTSD moving through the committee as it did here, the
Medical Marijuana Review Panel.
The panel, and we're going to hear more about that. It's not final, but we've heard other blurps on the radar before that this was going to happen, and it hasn't, so we want to make sure that we follow through on it. But the show's called Section 8 and PTSD. It was kind of a play on words for the jokingly, of course, I'm not trying to make light of the seriousness of PTSD, but like what happens in these Section 8 hearings is so traumatic and so shocking to a person's conscience, and the way in which it's being utilized to really find really every potential loophole to eliminate an individual for presenting that defense. Now, part of the reason that I've always, I'm talking about at the beginning of the show and throughout the importance of the doctor-patient relationship is because of this. It's because of the foreshadowing of that these kind of things were going to come, knowing that if there is something that's going to be attacked, it's going to be the physician. The Supreme Court has done a lot of things good. There's been things they could have done better as they've related to the Michigan Medical Marijuana, but they've, basically said any and all issues are to be resolved in the setting of the Section 8. That's your place of resolve. And I know it's not where people want to find themselves, and it's not right. There's a lot of ways that the Supreme Court could have given more protections on the front end, the immunity section, the exemptions section, expanding that instead of limiting it like they have. But if there is a silver lining, it's you have this Section 8 affirmative defense. And really for a substantial period of time, once the Supreme Court in King and Kalanick, and then in Balsma, and then in McQueen, and then in Kuhn, and then in Tierbeek, over and over and over again, the Supreme Court has validated certain very critical and fundamental principles of the voter initiative. And one of them has always been the right to present a defense, the language from the ballot initiative. And they've done this in a way that has always allowed for this proceeding to take place, and the rules and the tools that they have given us in these cases that I've mentioned, especially one that I had mentioned, but People versus Anderson, which was our good friend John Targowski's case out in the western part of the state. It told when the judge is sitting and evaluating the Section 8 hearing, there's not a lot of scrutiny that should be given, essentially, that by stating and coming forward and making the averment and something other than mere assertion should establish the prongs of that are necessary, the three prongs of Section 8, in order to at least get it to the jury, if not a dismissal. And it's been going down this path, and it really created some tremendous tools for people to defend on. I'm not saying that they don't exist anymore, but if there was ever going to be a place where those tools were challenged of winning as the voters intended, or at least taking the opportunity to use the act to defend yourself, and if not getting to dismissal, getting to a jury and being able to explain the affirmative defense and getting not guilty verdicts, passing the message to the community, from the community to the prosecutor's office, to the police, that these are not the types of cases that they're going to tolerate, and if they bring them and they're tried, they're going to return verdicts of not guilty. It's one of the paths I've always suggested to salvation, to stop the attack on patients and caregivers and basically back off on all forms of marijuana reform or marijuana prohibition. And there's evidence of this because the first place that the challenges to the Michigan medical marijuana came were from preventing people from presenting a medical marijuana defense before a jury. And we saw the craziness of what had taken place for a while of people not being able to talk about their medical marijuana card, defendant statements being redacted about their medical marijuana use and just leaving in the aspects of either manufacturing or growing marijuana. I mean, it was really, really crazy. But the point being that, of course, the Supreme Court said this is not the way it's supposed to be. This is a voter initiative. They voted for, paragraph 4, the right to have a defense to any charges involving marijuana, whether you're registered or unregistered patients or caregivers. And we're going to do that. We're going to give it to them, but we're going to put it in Section 8. So, but now, after these basic fundamental principles had been codified that everybody knew about, everyone believed, and everyone who was in touch with the law understood to a certain extent it was like this, and the insanity of the idea that it wasn't like this, or that there was one part of the law, that there wasn't a difference between Section 4 and Section 8. If you had 13 plants, that meant you were out of luck of using the act at all or defending yourself as a patient. That was the environment, and that was, but the Supreme Court cleared all that up with a overwhelming majority, 7-0 vote in People versus King, and we've had this Section 8 defense, which has really allowed and given us a pasture for patients and caregivers to explain medical use in a way that has not really been told before, in a way that allows an explanation as a defense to manufacturing marijuana, possession with the intent to deliver marijuana, or delivery of marijuana with some other defense other than the police are lying or it wasn't me. But instead to own it and say, yes, that was mine, that was ours, we were possessing, we were going to deliver it, yes, we sold it, yes, blah, 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 but it was for these medical reasons, and really allowing an explanation and for all different aspects of it. And what subsequently has happened is there's been two outrageous decisions. We've talked about them on the show in previous episodes. I would check Archive 185 through wherever we are right now, 189. But nevertheless, their cases are People versus Hartwick and People versus Tuttles. An interesting procedural side note on this is that these were started as appeals from trial court rulings where individuals had brought their Section 8 defenses, primarily resting on the cards in one case and the other one involving a undercover police officer, an undercover patient acting on behalf of the police. But nevertheless, these cases were denials of the defendant's request for dismissal pursuant to Section 8, and it was a denial of in the alternative to be able to present an affirmative defense about medical marijuana to the jury. So they were appealing these rulings of the trial court to the Court of Appeals. The Court of Appeals looked at both these cases and said, "Nah, we're not interested. We're not going to listen. We're not. Nope, no, thank you." And of course, the defendants then appealed to the Michigan Supreme Court, which said, "You know what? You're going to have to hear these cases, and we're remanding it, forcing you to do this, essentially." And they, I've joked in the past, the Court of Appeals said something to this effect: "Oh, you're going to force us to write an opinion that we didn't want to even bother with? Okay, let's write the opinion for you. Okay, we're going to put something together, maybe the worst written opinion of all time, and we're going to dump it out there to destroy what you've already cleaned up and made very, very clear for patients and caregivers to utilize the way the law has been intended, and we're going to just dump one out there and just mess it all up. And then it's going to be appealed, and you're going to have to clean this up." Well, that's what's essentially happened. And two cases, Hartwick and Tuttle. I know that the attorney that we're working with is, the application's been filed. They're waiting on the transcripts. There's a process in place. There hasn't been an official acceptance of it per se, but they're interested, and I would suggest from just that procedural history that they forced it into the Court of Appeals, kind of knowing that it was going to be revisited. But this is not a new issue, and I want to believe that the Michigan Supreme Court is going to be just in this, but let me just get into one of the critical places by which we find ourselves right now as regards to the patients. Now, I will tell you that, we know we have the amendments to the definition of bona fide doctor-patient relation. We know that it extends now beyond just the meeting and the recommendation and requires follow-up care and in an attempt at least to try to find the medical efficacy involving the use of medical cannabis and treating the conditions. And I understand that as a general principle, but the recent cases that Tuttles and Hartwig would seemingly throw this burden onto the physician of knowing and understanding the concentration of the various THC or CBDs or THAs or what have you, and knowing what levels are supposed to exist inside of the patient's bloodstream, to know exactly how much they're using, as if that's a thing that one could be identified in today's current situation. We had Dr. Paul Myers on the witness stand in the Cannabis Cancer Project case. He was the physician for the accused, John Roberts, and was asked, how much are they supposed to use? How much are they supposed to use of that? He's like, I can't give you that answer because one person's bag or container of marijuana may be very, very low THC and very, very low CBD, and they may smoke an ounce of it a week, whereas there may be another container of marijuana where they have super high THCs and a lot of CBDs or whatever. It doesn't even matter. They need a couple puffs a day instead of what the opposite would be. So it's too difficult to say at this point, and we are not there yet. The doctors don't have access to it, and even if they did, there's not a consistency by which a physician could really articulate it, and nobody's there yet. Now, I say that because not that it shouldn't be, not that it couldn't be, not that it couldn't go in that direction, but I think that have to be in a lot. Doctors would really need a federal government approval to begin research on it. And why do I say this? Because the legal argument, the legal issue that I see problematic here, and I've encouraged physicians to be more involved myself. I want the physicians to be able to articulate some basis by which, or a treatment plan or whatnot. But this issue has become overdone in these last two opinions. The idea that the physicians are supposed to know how much to use or to tell the caregiver how much is supposed to be used, how frequently it's supposed to be used, is well beyond what a physician should be required. Now, why do I say that? Because this issue has been addressed long ago in the case of that ultimately ended up in the Ninth Circuit Federal Court in Conant v. Walters. And this is a case which is right on point and addressed this. And what had happened was there was an injunction filed by a Doctors Association against the federal government trying to prevent them from taking the licenses of physicians that were participating in the recommendation process in California. And it went through the courts, and the trial court of the federal district ruled on it in favor of the physicians, and now the Court of Appeal, the federal district court, heard this case and ruled as I'm going to speak, and then it was appealed to the United States Supreme Court, and they denied hearing it, which suggests that this ruling was the right ruling. So, the Conant v. Walters was fought on a lot of different fronts. The U.S. Attorney's Office was really looking for any way to try to stop doctors making these recommendations. And essentially what the Federal Circuit Court of Appeals, Ninth Circuit, said was, what the doctor is doing is participating in a fundamental First Amendment right, that the physician is having a conversation and speaking and talking and counseling patients. And they should be able to do this, that our system of government would encourage this, that we want people to have the best possible health care that's available to them. And at the very minimum, the doctor should be able to have a private conversation with them about that. This is a First Amendment right. The doctors are doing nothing wrong. And what they're speaking about, whether it be, burning a flag or, whatever would be offensive kind of language, it doesn't matter. The content is not an issue. It's the right to speak it. You cannot criminalize speech based on the content itself, which is essentially what's taking place here. And one of the other arguments that was made, and this is how we get into the conflict with Tuttles and Hartwick, is that one of the arguments made by the government at the time was that the government argued to the court, if these doctors are recommending marijuana, then they're participating in a conspiracy or aiding and abetting them in getting marijuana. And this would be a violation of their DEA licenses and subject them to criminal prosecution. And the federal court actually affirmed or reaffirmed what the trial court had said, the district court, federal district court, which said, we are not going to impute upon the physicians the knowledge that just because they made a recommendation to their patients to use marijuana, that they actually are going to do it. Meaning it ends at the point of the recommendation. It ends at the point of saying to them, yeah, you may want to try this. Now, what does this mean for Michigan? I mean, if you compare the two, we're going down a dangerous road, because the more and more they're going to require of the physicians, first of all, it's not workable, because the place by which a physician could draw the information to make the kinds of decisions and say the kind of things that are being said, that have to be said in Hartwick and Tuttles, just do not exist, not yet anyways. It's creating an impossibility requirement for the physicians to know exactness in terms of dosing, exactness in terms of quantity, and exactness in terms of frequency of use. Now, the act itself that's necessary, that the Supreme Court hopefully would draw from this as well as from Conant v. Walters, and draw a conclusion that under no circumstances should the physicians be pulled out of the limited capacity of them having a bona fide relationship with the patient and recommending that marijuana may be palliative to them, and it ends there. And they may supervise them to see how it's working and what their condition is overall. They may report to them things, but beyond that is well beyond, and far into what is described in Conant v. Walters as a conspiracy to violate the Federal Controlled Substance Act. And I hate to think that the Court of Appeals would think that by requiring physicians to do this, that they wouldn't subject themselves to that. But at the same time, they use the word in both of these opinions 7 times. In each opinion, 7 times the word prescription is used. Prescription is used. What they say in Conant v. Walters is this is not a prescription. What the doctors are doing is not providing a prescription. So do not call it that, and therefore do not require of the same. So Hartwick and Tuttles has already been ruled on by the federal courts. I think that this is a really devastating, bad opinions, and for a number of different reasons, really misses the point and the purpose of the act. Now, I understand the complaints. I understand the need to have a bona fide relationship. I understand that, the appearance and the way that things have been manipulated of the Dr. Mills, and that every judge thinks that anyone get a card anywhere. And it may be true. I don't know. The point is that has nothing to do with the requirements of the physician thereafter and their knowledge and what they're asking. In fact, the reason that the new condition panels exist is so that physicians don't need to know the exactness of how cannabis may affect someone's hepatitis C. That you don't have to know how much cannabis is necessary for chronic pain, because the state has already told us by making it a condition on the list, by research and by whatever methods have gone through, which we're going to hear about tonight. They've come up with these solutions and given the condition. So when a doctor sees it, diagnoses it, he can recommend that it may be something that will provide palliative and therapeutic relief. So, in closing, why does one get PTSD from a Section 8 hearing? Because this is the kind of nonsense that's going on, a real devastating, really intellectually dishonest attack of what the Supreme Court had carved out as a very, very fair way to defend oneself in court. And I'm hoping that when and if they get the chance to hear these cases in a fair light, they're going to make the right decisions and overturn these terrible, terrible opinions. right, that's the rant for right now. We got, I don't know, I probably went on too long. But we're going to take a quick break and come back and get right into it. We're going to do some news when we come back. And then we've got Dave Brogan from the new conditions panel who can tell us about the PTSD and what it's all about. So we're going to take a quick break and be right back. You listen to Planet Green Trees.